and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hi, Richard.
Hello, Lizzie. The last podcast before I have a week and a half off.
Yeah, very much deserved as well. So before I let you go off on your holidays, we're going to talk about a webinar that we did back on the 30th of July. The webinar was Landlord Tenant Act 1954, when it applies, including upward and downward rent review. And we were inundated by questions. So we're going to try and run through some of those questions now.
Mm-hmm.
So the first question, or this person's saying, I would really appreciate your thoughts on what happens at the end of a pre-1954 Act ground lease. For example, where buildings have been constructed on the land by the tenant. Do the land and buildings revert back to the landlord, or does the tenant have a statutory right to a new lease, but on an occupation rent basis as opposed to on a paying a ground rent?
It's not actually clear in the 54 Act, in Part 2 of the 54 Act, but the consensus seems to be that it's retrospective, mainly because the definition in Section 23 refers to any tenancy. If it's if you've got occupation under a lease, at least partly for business purposes, then it refers to any tenancies which people have interpreted as meaning it's retrospective. There's also a reference in Section 37 of the Act about compensation, saying that you can't claim compensation, sort of prior to the Act, if you like, unless there's been continuous occupation for 5 years. So the suggestion is that although I've never seen a case on it bizarrely, but the 54 Act will continue to apply. So when the long lease comes to an end, then statutory renewal, and presumably in the absence of agreement between the parties, the rent will be determined as the rent's always determined. So that's, I'm saying it's not 100% clear, but that seems to be it, with a disclaimer on my part.
Thank you. The next question. A tenant of a large commercial premises wants to rent out individual offices on tenancies at will. However, each room will be locked and exclusive occupation for that subtenant. Should the tenant be issuing leases rather than tenancies at will?
Well, you've got problems. I mean, that's not what tenancy at will is really designed to do. I mean, it's if you're sort of tendering rent and you're not negotiating a new lease, it's even if you've created an express tenancy at will, I suspect that's in danger of being seen as something besides a tenancy at will. If it was that easy to exclude the Act, I think everybody would be having tenancies at will. There's no need for contracting now. The problem for the tenant is if they are creating leases and subleases, they're probably coming outside the 54 Act themselves, because you have to be in occupation, and the subtenant would be the one in occupation and not the tenant. So I think they've got an issue there. So it's a tricky one, but as long as the tenant realises that they might just be losing, their security, that sounds like a lease to me. That sounds like a situation where you should have a sort of proper lease.
Just to be clear, that an express tenancy at will can be excluded from the 54 Act.
They're not excluded as such. There was a case in 1956 called Wheeler and Mercer in the early years of the 54 Landlord and Tenant Act, which basically said tenancies at will, genuine tenancies at will, are outside the 54 Act. It's not the fact that they're sort of one of the exclusions, they just don't come within in the first place.
If an excluded tenancy ends and the tenant has been issued a tenancy at will but is refusing to sign, does it put the landlord at risk? In this instance, there's ongoing negotiations for a new lease.
I think it's a difficult one. That's why they're refusing to sign. But you don't need signature for a tenancy at will. It's good practice to show that both people are sort of singing from the same hymn sheet, but it's not necessary to have a signature. Just like it's not necessary to have writing, but it's probably good practice to do so. It is good practice.
Then what's the next question referring to? Does that apply to adding a right of way? Does what apply? Do you know?
I think it's must be to do with when I was talking about surrender and re-grant by adding to the premises it gives rise to an implied surrender and regrant or all adding to the term. So I think that's what it is. If you grant an express right away, would it be the same? Never seen a case on it, but the case, well, BGAS and BHP was in the notes, and also Friends Provident and British Railway Board, which is a 1996 Court of Appeal case, where it was Lord Justice Slade, I think it was, who basically said that the two situations which would give rise to a surrender and regrant, and not just a variation, would be adding to the demise, the actual estate in the land, and or adding to the term. There have been suggestions otherwise, but you're not adding to the actual estate if you're creating an easement. A beneficial easement. So again, it's an interesting one, that actually. But I don't think there's a 100% answer, but probably not a problem, with a disclaimer.
Always a disclaimer. Next question. Is it just adding extra land that takes the lease outside of the Act? What about varying the demise by just taking some land away?
A Friends Provident of BRB said it's adding to, and they also said that you'd be hard pressed to think of any other circumstances besides adding to the demise or adding to the term. There have been suggestions otherwise, and the land misuse practice seems to be to assume a surrender and regrant to take away. There was an 1878 case called Jones and Bridgman, which wasn't about taking away. It was basically about changing the rent when part of the land was taken away. And although it's an old case, that suggests, I mean, if I was erring on the side of caution, I'd say it's taken away as well. I'd assume, if that could be a surrender and regrant, but I got my doubts about it.
The next question. If you do not collect any rent under a tenancy at will during the negotiation period, how do you insist that rent should be backdated to the end of the previous lease? If not, surely the landlord is losing income during this period.
You could claim, presume, mean profits based on the fact that they've been an occupation. Contrary to what a lot of people think, then there's been a lot of cases where you've still had a tenancy at will because you're negotiating the final lease. Jarvin and Aqil was the first Court of Appeal case in the early 1990s. So you can actually accept rent in advance as long as there's negotiation going on. But, if there's no negotiations, it's time to make a decision as to what the future holds. So I think that's probably the way of doing it.
Okay, next question. With the Grayson case, what about the areas outside of market stalls, walkways, etc., that the landlord is responsible for? Doesn't that constitute occupation?
Yeah, but in Grayson, they said there's quite a few cases that have said the same thing. If you take away the market stalls, there was these 35 market stalls in the covered market in Liverpool. And if you take away the market stalls, you're not left with a business. You're just left with a load of sort of common parts and the likes. There's been 2 or 3 cases. There's a case called GP and Baggett's, which have said the same about sort of subletting on a residential basis. You might retain the common parts, but the subtenants in occupation and take that away. You're not running a business. So I think that's the solution to it.
Next question. Can you have a contracted out license?
If it's a license, it won't come in within the 54 Act in the first place. And so you wouldn't need to contract out. But just because you call something a license doesn't mean to say it's a definite license. It could still be a lease. And if you've got any doubts whatsoever as the landowner, what should you do, Lizzie?
If in doubt, contract out.
That's Lizzie's catchphrase. Mm-hmm. Yeah, I just, if I got any doubts whatsoever, I'd assume it was a lease and exclude the 54 Act.
Perfect. Can you expressly agree between the parties that it is a licence?
No, if you've got exclusive possession for a term at a rent, it's a lease no matter what you call it, unless it's an exception. The major exceptions being things like service occupiers, where you're caretakers for the better performance of your job. But it's Street and Mountford, 1985, House of Lords case, where Lord Templeman said that if you've got a 5-pronged instrument for digging, it's a fork, even if you call it a spade. which has always annoyed me, Lizzie, because forks don't have 5 prongs.
Yeah.
They have 3 or 4. But I've never seen one with 5, but it just ruined everything for me. But anyway, yeah, so no, it's the nature of the thing that matters.
In light of the AP Wireless case, would a case based on Thomas van Staden's definition of the term be ripe to be distinguished on the basis that it's not a term certain and therefore not a lease? That point was expressly not argued and therefore not considered in Thomas van Staden.
Yeah, this AP Wireless case on Tower is this bizarre case from late July, Court of Appeal case. Now, we got a podcast on which basically, dealt with the fact that to have a lease in the first place, you have to have not just exclusive possession for a term, but you also have for a rent at a rent, but also you have to have a fixed maximum duration. You know what the maximum duration is from day one. And that was a 10-year lease, and either side could give 12 months notice, expiring no earlier than the end of the 10-year period. And the Court of Appeal decided that didn't have a fixed maximum duration with amazing consequences. It wasn't dealt with in Thomas van Staden. Thomas van Staden he had a fixed term, and then the term was defined as including any holding over period. I mean, frankly, the courts have got themselves into a real mess on it. I think the most important case is there's the House of Lords case called Prudential and the London Residuary Body, the successor to the Greater London Council from the early 1990s, where it was a lease for the duration. The landlord could only terminate it if they required the land for road widening, and the House of Lords, as they were, said that that's not a fixed maximum duration, but had they been paying the rent yearly, it was a yearly periodic tenancy, and that is a fixed maximum duration. Either side knows what notice they have to give at any one time. In the Thomas van Staden case, there's a lot of cases. I mean, Walsh and Lonsdale itself, listen to the podcast, but dealt with these kind of things, and it just seems to have been missed out in the AP Wireless decision. So I doubt whether it squares nicely with the House of Lords case. There was another House of Lords case called Mexfield and Berrisford, which was a strange decision, which they seem to prefer, even though it was only obiter, if you know what I'm saying.
I do.
Can't be squared with a lot of cases. Listen to the podcast.
Next question. Can we expect to see upward-only rent reviews banished from non-protected acts in time?
Not non-protected, non-54 Act leases. I think there's no suggestion of that whatsoever. I mean, the proposed ban on upward and downward rent review seems to assume it's a 54 Act lease, including a contracted out lease, but within the definition of Section 23. So it wouldn't apply to AP Wireless if you take it at face value.
Next question is, do you think they will be banished from residential tenancy agreements too?
Nothing would surprise me at the moment with politics the way it is, but there's no suggestion of that now.
Next question. When an excluded tenancy ends and there is a gap of a few months before the start of negotiations for a new lease, in this situation, does the tenant acquire a periodic tenancy under the 54 Act?
Well, that Valley View case in the NHS Property Services from 2022, there doesn't seem to have been any negotiations, not at the end of the fixed term, but at the beginning of the lease for years. What the court decided was still a tenancy at will. You've got to have negotiations. Without negotiation, or an express tenancy at will, I think once you start certainly having a pattern of rent being accepted, you're in danger of it becoming a periodic tenancy within the 54 Act. And I would assume that's the case, and deal with it accordingly.
Next question. Are long leases protected, 99-year plus?
Yeah, I mean, there's no limit to duration under the 54 Act. It's a strange thing to do, but they could come within the 54 Act.
Does an express tenancy at will risk being deemed a protected lease if it's in place for a long period of time?
Again, in spite of that Valley View and NHS Property Services, which you've got to assume is a bit iffy as a decision, I wouldn't want them to last too long, but we have got Court of Appeal decisions like Erimus, where it was over 2 years negotiating fairly half-heartedly, although they did get as far as heads of terms, and it was still a tenancy at will. I wouldn't want them to last too long.
Next one, if an excluded lease is held over, does it become a protected tenancy?
Again, if there's negotiations according to Erimus and Barclays Wealth, then it can be a tenancy at will. But if there's no negotiations, if both parties have to be negotiating towards creating a new fixed lease or whatever, then it can be a tenancy at will. Otherwise, if there's no negotiations, once a rent pattern emerges, then it'll become 54 Act protected. You'll also lose any guarantors, and 54 Act protected unless you've served the contracting out notices, and also you lose your guarantors unless you've got written agreement of guarantors. It's got massive implications elsewhere in terms of SDLT and various other taxes as well.
This person is agreeing a license specifically for erecting an advertisement hoarding for a period of 2 years. Should they be agreeing a lease instead?
Well, again, we don't do real life situations, but hypothetically, we have that Manchester City Council Clear Channel case where it depended on the nature of the agreement. If you've got a sort of defined area where you can put the hoarding, that's a lease. But according to Clear Channel in Manchester, not otherwise. But if I had doubts whatsoever, what would I do, Lizzie?
Contract out.
Yeah. If I've got doubts whatsoever, I'd assume it's a lease and get it excluded. You can exclude without prejudice as to whether it's a lease or a license. And I think I'd probably do that.
Next question. In order to prove contracting out is a signed stat dec required, or will the clause in the lease be sufficient confirming the lease is contracted out?
No, you've got to have a stat dec if there's less than 14 days running period before the tenant commits themselves, and if there's 14 or more days, you can have a simple declaration. But they are requirements before there's contracting out. Without that, you're not excluded.
I think we've kind of already answered the next one, but if there's a doubt over whether an agreement is a lease or a license, could contracting out have a bearing on the decision?
I think, I'd serve the notices without prejudice as to whether it's a lease and a license or license.
And final question, what will happen with reviews that are to the greater of open market rent or RPI, probably with a cap and collar?
They haven't actually dealt with it too much at the moment. If you've got several ways of calculating the rent, they'll all be if it's can't be ascertained from the very beginning, they'll all be subject to the fact it could be downward as well as upward. But it's not really dealt with in the legislation. Could you hedge your bets in those circumstances? Collars on the face of it are going to be banned as well. Would fall foul of the legislation if it comes in its current guise. But the Secretary of State is looking at what to do about collars quite separately. And there are provisions in the legislation as it stands, a bill which allow regulations to be passed in various other areas. And there's a suggestion that collars might be dealt with later. Thanks. Well, that's it then.
Thanks very much, Richard.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.